Okay, so Mr. Sherrill, you're charged with terroristic threat. You're facing up to a year in jail and or a $4,000 fine. We have already done probable cause. I found probable cause to go forward with your case. We set a bond. He's made the bond or no?
Yes, he has.
You've made the bond.
Yes.
Okay. So I am entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Taylor as a protected individual.
Okay, pause. Let's break that down. What you just heard is a magistrate's order for emergency protection. It's a serious court-issued warning. Think of it like a legal force field around the victim. No contact, no weapons, and definitely no surprise run-ins, even at something like a wedding. And yes, even if the accused believes the victim is still talking to mutual friends, none of that matters under the law. This isn't about personal feelings. It's about legal compliance.
You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? They're not currently together now?
No.
Okay, great. So there's just no,
So,
I don't want to talk about the case.
no, it's not. She still like communicates with like my family and my friends. Like I don't even live here, and it's events coming like my best friend's wedding. I'm going to the wedding, but she's trying to come. So how do I have
Got to be careful, you know, you're not to have any contact with her, you know.
Sounds like she's using, I don't know if she knows there's a restraining or a protection
She
order.
is using, the officer was a personal friend, so that's why.
Okay, well,
So this merely says that you can't go to or near her residence, right, where she lives, where she works. Don't have any contact with her. The problem is that there's a lot of vindictive people in this life. You know, if you go to the same place that she is and you end up bumping into each other and she says something to you, you know, it's a recipe for disaster. So you have to be very careful. If you go to this wedding and she's there, it's like a ticking time bomb. So you need to be just very careful because I don't know, you know, what kind of person she is. If she's that type of person, you got to be very careful because there are a lot of people that will call them and say, hey, this happened, when it's just not true. And if it does, they issue the warrant and then it's up to you now. You pick up another charge. So just be careful, you know? All I want is just you not to have any contact with her. Don't be in possession of weapons. As long as you can do that, we're cool. I'm going to waive your appearance so you don't have to waste your time coming to court here as well. Just stay in touch with counsel and he'll tell you if and when you have to come back to court here. So you don't have to come back and forth every single court date. Just stay in contact and he'll let you know if and when you have to come back.
I appreciate it.
Do you have any questions?
I guess so.
You live in Baltimore, right? Okay. So for now, what I'm gonna have to do is I'll have you sign a reset with Victoria. We'll have you take a seat in the juror box. We'll get your bond conditions, I'll have you sign it, and after that, you're free to go. Okay? Hi, Anna.
Good morning, Judge. Hi, Bruce.
Yeah.
I've got a couple to talk to you about this morning.
You do the easy ones first?
Well, whenever I have to talk to you, Judge, they're never easy.
That's not true.
Fair enough, fair. But these,
We're talking about 15 to 20 students brawling at school. This is starting to sound less like high school and more like a WWE pay-per-view. But here's the legal twist. When one student tries to block an officer from breaking up the chaos even by just raising their hands and saying no, that's called interference. That it doesn't have to be violent. Intent and obstruction alone are enough to trigger a legal response. So what do you think? Should simply standing in the way be considered a crime? Drop your thoughts in the comments.
Okay.
the first one is going to be Wilson Keonje. Start with the less difficult.
Okay.
Can we hear PC on this one?
Is it, you say Keontae? Keonjae?
Keonje.
Okay, yeah, of course.
On February 6, 2025, a law enforcement officer was dispatched to an assault at Provision High School. Law enforcement officer arrived and observed 15 to 20 students fighting each other and struggling with staff members and security guards. The law enforcement officer retained a number of students. After the scene mostly calmed down, the female was struggling and fighting against male students to run out onto the floor and rejoin the fight. The law enforcement officer approached the males and told them the female students' hands behind their back. The law enforcement officer got closer to the defendant, turned towards the law enforcement officer, put his arms up to stop the law enforcement officer's progress towards the female and said, no, no, no. The law enforcement officer grabbed the defendant's shirt and told him not to interfere or he'd be taken to jail. The defendant replied, I will, and remained in the law enforcement officer's path. The law enforcement officer handcuffed the defendant and ordered him to get on the ground and began pushing the defendant towards the ground and told him to get on the ground again. The defendant remained on his knees, pushing up against being pushed. The law enforcement officer pushed the defendant down towards the wall. The defendant pushed up, causing the law enforcement officer to fall to the ground. The defendant righted herself before continuing to struggle with the defendant to get him to the ground. I believe that's a typo. The law enforcement officer righted themselves.
So there's a fight.
Yes, Your Honor.
The officer is asking him to move, get out of the way, so he can do whatever he needs to get done, and he just refuses to get out of the way.
Yes, Your Honor.
Anna?
So it sounds like the interference is my client doing this.
He's impeding the path of where he's trying to go or what he's trying to do,
Okay.
right? I mean,
That's what I have, Your Honor.
is there a body cam on this?
It looks like we do have a significant amount of video.
Have you seen the body cam? Does it show that?
I have not watched them all because it's quite a bit, Judge.
Okay.
But
I mean, remember, it's a low burden,
I understand.
probable cause, and he's, the officer says, hey, move, man, I got to get this stuff done. And he's like, no, I'm not going to move. I'm going to stay here. Just, I mean, I get it's just standing there, but
Okay,
so look at the video. If you see something different, let me know.
okay. The next one I have to talk to you about is Torrance.
Come on, Ms. Torrance.
I've spoken with the state. And so there's kind of a couple of things going on. I'm assuming you want to do the BVR first. I've spoken with the state. We are going to ask for a hearing. I'll let the state speak for themselves because
Your Honor, we do not have any toxicology bag. We have blood alcohol report, but that is not the toxicology report.
Well, talking about the bond violation
Bond
report.
violation, I apologize.
It's okay.
I apologize.
I don't think the state is prepared to have the hearing today. But
I've got bond violations. The Scram device has confirmed alcohol consumption violations on 3/15/25 at 1:51 p.m., 3/23 at 7:14. Confirmation was received 3/25/25 by the analyst, and it's a third bond violation.
I understand, Judge, but
Let her go.
the rules of evidence apply at a bond hearing, and we need somebody with personal knowledge or somehow to get around that hearsay to do the hearing, and I don't think the state's prepared to do that today.
We do not have anyone here to do that today, Your Honor. I apologize.
Hey, who do we need? What Scram analyst do we need to get down here? So we can, right, so they can testify that what's in the BVR. I'm sending her now for a drug and alcohol test right now as well.
I'm going to send her for the test now.
Right now.
Okay. Okay. Have a seat, and then once they put the order in, we'll have you go over there. Okay.
She can head over to 43.
Okay,
It's good.
okay. You go over to 41 San Jacinto? Okay.
And then Anthony, do you see, who do we have that can come?
Yeah, I'm
You
gonna get
mind?
the name and.
Yeah, okay.
We'll
We'll get it. I'm gonna try to get it today. Okay, who else?
And then, well, so the secondary issue, on Ms. Torrance is we have gotten the alcohol report back. They sent the, blood off to get analyzed for toxicology.
Oh, Lord, did you just send the blood on?
Well, and Judge, if,
No,
Verify when that.
this case is 233 days old and we have violation after violation. I'm not.
Too much drama, I'm setting it for trial. That line, pure courtroom energy, you can almost feel the judge's patience evaporating. Let's be clear, repeated bond violations, missing toxicology reports, and 233 days of delays, that's a legal recipe for frustration. Here's the takeaway. When a judge starts using words like drama, it's usually game over for plea deal negotiations. Trial mode, activated.
Waiting anymore. She's way too much drama for me and I'm ready to set this thing for trial. I'm not doing it anymore.
For the courts, I did email the person on that side, just got a response. Toxicology analysis still in process, pending completion, it's likely requires some time before the lab board proceed.
Did you just send them?
No. We've been sending follow-ups. This was like a last Hail Mary attempt of, do we have it or do we not? They still have it.
Do you have other things to go on regardless?
I think we
You
have.
know?
Spoke with defense counsel, there is, from a proper, there was alcohol in the system.
Well, look,
We have-
it doesn't matter to me, however you guys want to do it, but to me, way too much drama. I'm setting this case for trial. That's it, you know, because
Yeah, and he has laid an offer. I just,
I need to talk to her about the offer. If it's not moving anywhere, I'm
okay,
setting it today.
Okay,
Way
and-
too much drama.
just to remind the court, when I was here last time, you gave them 30 days and said if they didn't have the report, that it wasn't coming.
Okay.
I understand the state has to do its job.
So can you take a look and then, you know, take a look
Absolutely.
and then let's go. But yeah, I'm ready. Hi, Maverick. How are you, man?
Good, good, you?
Sorry to bring you down here.
No, it's good.
Is your client here?
He is. Let me bring him
Come
up.
up.
I did speak to pretrial and they did confirm that they are kind of in the mistake. We did not comply. This is because we did come here to court on a Monday, 4/7. And when you were here, you already knew his results.
Last meeting.
Oh, Bennett.
Okay.
And so you already knew his results and you told him, look, I already know your results. There's no use to test him on Thursday. Because he was on a Monday, Thursday at the time. Let's switch him to once a week. We can't tell him when he would be tested next week, but you know, which day, but sometime next week he'll be tested. So on Thursday, they of course call him and he's like, okay, I already was told not to do it. And then he did not go. And so it put him in the system as a BVR. When he was, in his opinion, following directions.
Okay, I'm gonna send him now, I
That's
guess.
fine. And they even said.
As long as you're
today.
clean, I'm happy. I just don't want anything in your system, especially oxy. You know, that's all I want. I'm not asking for much, you know? We'll send him for a test now. Hopefully he's clean. If so, everybody's happy. I won't ding him on this. You know, if he's dirty, I don't know what we're gonna do. So let's do this, because it's gonna take a while and I know how busy you are. Leave me your cell phone.
I'm trying to court 3 all day today.
But I can text you, so that way you don't, you know, don't say it.
Okay.
I'm here. If you write down your cell phone, please, and then I'll text you. All right, just take a seat for me. We're gonna send you here momentarily, Mr. Ben. Hi. Hi,
Lacey Johnson, Mental Health Division Judge. How are you?
great to see you. What's new?
Yeah, just trying to do some more work in misdemeanor. And if you haven't heard, we are supposed to be having full-time misdemeanor mental health prosecutors coming online in the next couple months. So we're very excited about that.
That's exciting.
But in the
Well-
meantime, we're trying to,
Guys that you have now are great. They're
I-
just so understanding and great.
yeah, well, I
Hey.
think there's a lot of things we can do to help in misdemeanor court. And so that's what I'm here to hopefully do today. On Mr. I beg your pardon if I'm butchering his name, El Majzoub.
Yeah,
Okay,
that's correct.
he is on docket today. I can give you a case number if you
See
need
him
it.
in
Yes,
custody?
he's in custody.
Are you handling just mental health? No.
Yes, I'm handling just mental health.
Is that recent?
Lori and I are just handling mental health.
But is that recent or no?
No, since I've been here, I've just been in with mental health.
Okay, what was the cause number?
So his first cause number is 255-6958.
And that's the document that I filed. It was the agreed stipulation of evidence. That's what we filed.
And so I got a notice that she had filed for a motion for competency exam. I took a look at the cases. This gentleman has been through competency restoration services before and has a well-documented mental health history. And so I told her, rather than waiting for an exam, which I feel fairly confident I know the outcome of, I will agree to stipulate that he is incompetent so that we can go ahead and get
Great.
the services started. So what we're asking you to do today is to sign the stipulation of evidence, sign your regular order that you would for competency restoration services.
Yeah.
And then if you could also enter the order for clinical assessment for outpatient or jail-based competency restoration. So if we can see if either of those options would be appropriate for him.
Huh?
Yes,
Yeah,
thank you,
great.
Judge.
Yeah, just, do you mind putting it in the queue? It's on Elma Zook. Page 32? Yeah, 31 and 32. Yeah. So everything's been already filed, right? So he just put it in the queue?
So
9 minutes?
the two orders are ones that should be in your order database, but I'm happy to confirm that those are the right ones once they've been pulled up
I don't
for you.
know. I don't,
It's
We
usually,
can take a,
yeah.
I don't usually file it.
No, it's usually should come from the clerks have it in their database.
yeah, that's one of the documents that needs to be signed.
So the order for competency restoration, and I can give you the statute if you need it. And then I can show you the other one, but it's called Order for Clinical Assessment for Outpatient or Jail-Based Competency Restoration.
That one. We'll get it. We'll get it, but it might take a
And I
second.
can show it.
Let's show them.
Okay, as soon as I get it, we'll sign it.
Wonderful. Thank you, Judge. And
Do
then
me a favor though, do you mind maybe like email all three?
Here on Javier Marin this morning,
Okay,
and I spoke with the chief. There was a mistake about it being a DWI second. In fact, the DWI first that they thought was the issue was actually reduced to a reckless driving charge. And so this is actually just a true DWI first. And the chief has made a time served offer today that I
wait
believe
a
might.
second. Can you run his NCSC, please? Because usually it's a DWI and they might reduce it to an obstruction or a reckless, but it's a DWI. Right? And the thing is that the last thing I want is for him to wrap his car around a pole because he continues to get proverbial slaps on the wrist, you know?
And then at this point, that's all you need to. If, so when you send these stuff together for the outpatient or jail-based programs, they'll send us back a report and if,
Sure.
is admitted to either of those programs.
So we did submit a PTI litigation packet for him as well, just under the assumption that.
I mean, that's up to you guys. The problem is it's 190 days old, right? That's should have been like a long time ago, right?
Yes, it's really.
Let me know if you need to come back. Otherwise, maybe want to check in and.
They filed it as a second, and I'll tell you, let me look at the information.
Sorry, give me 1 second.
Yeah, it looks like he was convicted of a DWI in Lawton, Comanche County, Oklahoma in '01.
Laura?
Yes, Your Honor, it was. It was a DUI. Okay. Sorry, I'm trying to decide.
Take your time, there's no rush.
And like I said, it looks like it that way, right, I was driving, but the DUI was dismissed. That's.
It was reduced and wasn't dismissed.
It says dismissed, I think, there's no language on NCIC.
So it said dismissed and then at the same time,
that
a reckless?
Says, dismissed in 2001, guilty, and then a guilty plea for a traffic offense. Then we heard the municipal prosecutor, Walsh. And then in June, so in. I'm not sure, it might have just been dismissed. Was it, how do you feel? Just.
It's from the attorney of record. He said that he was speaking with Abigail Balance. From my understanding, the previous introduced a reckless driving equivalent from Oklahoma, and then she wrote back.
I'm sorry, Your Honor, the NCIC just doesn't clear exactly how that transaction.
Yeah, it's not an by second. It truly is not. It was, we got
It's
to
reduced from it was,
I don't really have one Oklahoma. But it is not a DWI. That is.
was it a deal that got reduced or reckless or an obstruction?
All right, there you go. You're free to go.
Oh, Jane, that's higher. So I misspoke, Your Honor. We did not get a JNS back because there is no JNS from Oklahoma. Only thing I can see was there was a DUI charge, no information on it. It's hard for me to track, but there are no DWI convictions. So it's hard for me to track to see if that charge that we have that was, we don't need the JNS on, was the one that was.
They usually don't file it, just,
Right, because it was a class C. Or well, it's a mall, so it's different, but we did the equivalent of class C here.
what do you want? You
Left
want
of
time
center.
served?
We would like to give that offer to our client today because
I mean, we got to do something today. It's 190 days old.
it's today, but
Oh, it's waived.
could have it coming on the next setting.
Yeah, so what we'll do is we'll set you off a week. Okay, have your client come in so we can take care of it. You know, I'm okay with just, can you go ahead and do the reduction now? How do we,
So, yes, Your Honor, so what I can do is I could, because we're reducing it, basically I can run the fleet paperwork, Your Honor, we are changing,
well, we'll need the new NCIC regardless, right?
I'm sorry.
We'll need the new NCIC regardless.
Oh, yeah.
Do you know the NCIC by heart? On
In
the
Your Honor,
first?
the offer we've made, it's within the NCIC. It's
Okay.
within Class B.
Is it above a 0.15 or not? Okay, yeah, if you want it, I'm okay with it.
Judge, and also we did apply for PTI. I don't know if that might still be on the table.
Do you know, have you turned it in?
And as of yesterday, yes.
Oh, as of yesterday.
As of yesterday, Judge.
Do you see that it's been turned in?
So we submitted it to,
So regardless, I mean, do you want the PTI? Is that what you want?
my client would really like that. He would.
So go that avenue and we'll see if they are, down. You're probably, have you filed mitigation paperwork explaining to them that it's not a second though?
Yes, Judge.
Okay, great. Because they need to know, because they're gonna automatically refuse you if they think it's a second.
That was my whole look before I made this. But once I saw it, and I can tell you, Your Honor, the conviction is for passing on.
Okay.
Okay.
I just want to confirm that you have the image.
I don't know that.
It was sent to Lindsay Tizard
Oh, no. That's, okay.
and Flo Dufocon.
So let me.
You guys get together. I'll give you a week to 2 weeks to get the response and we'll go from there. Yeah.
Thank you, Judge. I appreciate it.
2 weeks. They're filing the PTI today.
Okay.